Justice. I will welcome the Honorable Chief Justice. He's on his way. Chief Justice, very warm welcome to you. We'll have the national anthem, please.
Dancing round, O Lord of nations, on the isles of Fiji, as we stand united under noble banner blue, and we honor and defend the cause of freedom ever. Together, progress, Fiji, oh Fiji, ever Fiji, let our voices ring with pride for Fiji, ever Fiji, our name goes far and wide, the land of freedom and glory. To endure and before, may God bless Fiji forevermore. Blessing on, O Lord of nations, on the isles of Fiji, shores of golden sand and sunshine, happiness and soul. Stand united, we of Fiji, fame and glory ever. All march together, God bless Fiji, for Fiji, ever Fiji. Let our voices ring with pride for Fiji, ever Fiji. Her name is far and wide, our land of freedom and glory. To and new and before, may God bless Fiji forever.
Standing for the judicial prayer to be led by the Honorable Chief Magistrate. The Honorable Chief Justice, speakers and trainers joining us online from the other end, judicial officers, representatives of the ADB and NJEC support staff. I'm Justice Vati from Fijian Judiciary, and I'm also the chair of the National Judicial Education Committee. On behalf of the Honorable Chief Justice and the National Judicial Education Committee, I welcome you all to today's webinar on international arbitration. I thank you all for joining us today. I take this brief opportunity to thank the Honorable Chief Justice for his permission to have the webinar. And my gratitude also extends to the ADB for organizing and funding the workshop. Thank you very much. Please accept my gratitude. Before I ask the Honorable Chief Justice to address us all, I take the pleasure of introducing His Lordship. His Lordship, the Honorable Chief Justice, attained his Bachelor of Laws qualification in 1999 from Queensland University of Technology in Australia. Subsequently, then in 2000, His Lordship was admitted as a barrister and solicitor in High Court of Australia and Supreme Court of Queensland. Then in May 2013, His Lordship started his legal practice in one of the most renowned legal practice in Fiji, at being young and associate solicitors in Lautoka. May 2013, his lordship joined the Fijian judiciary as the puisne judge of the High Court. And he held that position until 7th April 2019. As on 8th April 2019, his lordship was appointed the acting Chief Justice of the Fiji judiciary. His lordship since then is holding that position. And apart from his legal career, he has also served in other places as well. One being one of the most prominent places being the Fiji Human Rights and Anti-Discrimination Commission from September 2018 as the chairperson of Fiji Human Rights Commission. His lordship has done other community work as well. Being 2001 to 2006, he was the president of Lautoka branch, Western Division for Dakshina India Andhra Sangam of Fiji. And then he remained in that position from 2009 to 2012. And from 2012 till date, he is the national president for Dakshina India Andhra Sangam of Fiji. He is the past secretary and president of Rotary Club of Lautoka. He is the past assistant director, governor, District 9920 Rotary International. And he's also the past board member, Board of Visitors from Lautoka Hospital. His lordship, apart from his legal career, has shown a keen interest in training, and he believes that any form of training, any mode, any magnitude is always progressing us in terms of our knowledge and in terms of our work. Had it not been for his lordship's approval, I think any form of training would be difficult to kickstart off the ground. The lordship, in having said those words, I thank you very much for your approval to hold the workshop, and I request you to come forward for your opening remarks.
Honorable Madam Justice Angela Wate, Chairperson of the National Judicial Education Committee, thank you for your kind introduction and remarks. Honorable Justice Anselmo Reyes, Honorable Judges of the High Court, Mr. Thomas Clark, General Counsel, Asian Development Bank, Chief Registrar, Chief Magistrate, Resident Magistrates, Mr. Daniel Metz, Mr. Jonathan Lim, we are all there, Ms. Brenda Oregon, Ms. Christina Park, and the resource persons from Asian Development Bank. I've got some names here. I want to acknowledge your contribution, your presence this morning. Mr. Masayuki Tachiiri, the Regional Director, ADB Silver. Eric Albers, Senior Country Specialist, ADB Silver. Mr. Alvin Kumar, Associate IIT Coordinator, ADB Silver. Maureen Hazelman, Project Analyst, ADB Silver. And Lambas Sovia, Senior Program Assistant, ADB Silver. I'm sorry, I also didn't realize Masters of the Court are here too. I must acknowledge their presence for this morning. The members of our Secretariat, a very good morning to you, all of you present here. I, on behalf of the Judicial Department and Asian Development Bank, obviously very much grateful to extend a very warm welcome to each one of you to the second Judicial Colloquium on International Arbitration this morning. Those joining us from abroad, thank you for your kindness and generosity in taking out your time for this colloquium and Fiji Judiciary. In fact, I know there's a bit of time difference. maybe 4 or 5 hours behind our time schedule, because it's very early in the morning in your country. I thank Asian Development Bank for its commitment and desire to assist small island countries like us in ensuring that we all have dispute resolution system and competent court system. Provision of efficient dispute resolution system and competent court system will no doubt instill confidence in investors who plan to invest in our countries. In other words, investors look for dispute resolution system that is swift, determined by experts, is confidential, is neutral, and there is also a need to ensure that foreign arbitral awards are enforced without any difficulty. Fiji ratified the UN Convention on Recognition and Enforcement of Foreign Arbitral Awards, which is simply known as New York Convention. Our International Arbitration Act, which was enacted in 2017, is a comprehensive legislative framework based on United Nations Commission on International Trade Law model, on International Commercial Arbitration Act 1985, with amendments adopted in 2006. Our act came into force on 4 December 2018. To ensure that our act incorporates best practices in international commercial arbitration, it includes certain provisions from International Arbitration Act of Australia, Singapore International Arbitration Act, and Hong Kong Arbitration Ordinance. Some of the salient features of our act are obviously it binds the state. The state also enters into international contracts. An arbitration in terms of our act is international, is defined as to be international. If at the time of conclusion of arbitration agreement, place of parties' business is in different states. Place of arbitration determined as stated in agreement is different from their place of business. So if you are having business in Australia or in Fiji, then you want arbitration to be in Singapore, then it obviously becomes arbitration, international arbitration. Place where a substantial part of the obligation to be performed or where subject matter is closely connected is different to their place of business. Parties explicitly agree that the subject matter of arbitration agreement relates to more than one state. If parties have more than one place of business, then place of business which has closest relationship to arbitration agreement. If party does not have place of business, the reference to place of business is to be his or her place of residence. Obviously, the provision of the Act is to be interpreted in reference to arbitration model law with regard to international origin of arbitration model to promote uniformity. So here there has to be some consistency in interpreting those provisions. Obviously, Limitation Act, it would be good to know that applies to arbitration awards too. Arbitration agreement has been widely defined in Section 11 of the Act, which in summary are in following terms. An agreement by the parties to submit all or certain disputes arising shall be in writing in the form of arbitration clause in the contract or a separate agreement. Agreement can be in the form of electronic communication or data messages. Very widely defined. Can be by way of allegation in a statement of claim, which is not denied. Reference to a document to a contract which had arbitration clause. Court proceedings, dispute obviously can be referred to arbitration on request of party where that before the party submits first statement on substance of the dispute can be referred to arbitration, which means that if there's a court proceedings and somebody wants to go to arbitration under the agreement, then they have to move the court for stay of the court proceeding before they take any step in the court proceeding, which means before they file, if it's a ordering summons matter, if they file affidavit of service in opposition. If it's a writ of summons matter, before they file a defense. So before they do that, they must move the court for stay of the court proceedings and parties be referred to arbitration. Obviously, court decision to refer matter to arbitration is not subject to appeal. You cannot appeal that decision, but you can appeal the decision if they refuse to refer matter to arbitration. Obviously, if the tribunals have power to award interim measures, and so does the court, even if the arbitration proceeding is going on. In terms of jurisdiction, arbitration tribunal may rule on its own jurisdiction, rule on validity of arbitration agreement, rule on whether a tribunal is properly constituted, rule on whether matters submitted to arbitrators are in accordance with the arbitration agreement. Jurisdiction issue must be raised as soon as the matter alleged to be beyond scope of authority is raised. A party may challenge tribunal decision on jurisdiction to court within 30 days of receipt of the notice of the ruling. Courts also, as I've said, and tribunal have measures to grant interim powers to grant interim measures like interim injunction, interim restraining orders, and the conduct of the proceeding. Parties are to be treated equally, like we do in court too, and given full opportunity to present his or her case. Parties may represent themselves or can be present by person of their choice, by a solicitor. Rules of procedure: parties to agree on filing which arbitral tribunal to make procedures in line with. So parties are free to make the rules and the terms of references themselves for the arbitrator to consider those. Obviously, the tribunal can appoint experts and get evidence from the experts. Termination of arbitration proceedings. Obviously, when the final tribunal proceeding finishes. Order of tribunal when claimant withdraws claim without objection by respondent. Parties agree to terminate, or arbitral tribunal finds continuation of proceedings to be unnecessary or impossible. Obviously, tribunal has the power to correct its awards and interpretation of any provision in the award. Also, the court has the power to refuse recognition of enforcement of awards, where a party to the agreement can prove that he or she was under some incapacity, or agreement was invalid under the law it was subject to, or if no such indication, then under the laws of our country, laws of Fiji. Party has not been given proper notice of appointment of arbitration or arbitration proceedings, or was unable to present his or her case. Award deals with dispute not within the scope of submission to arbitration. As I've said, parties draw their own terms of reference for the arbitrator to look at and to determine on that. So if he goes beyond the terms of reference, that award cannot be enforced. Award is not binding or has been set aside or suspended by a court of the country in which or under the law of which that award was made. Or court finds that subject matter of dispute is not capable of settlement by arbitration or would be against the public policy in Fiji. Public policy: interim measures or award is contrary to public policy, said in the Act, if making of interim measures or award was induced or affected by fraud or corruption. There was a breach of national justice occurred in making of interim measures or the award. Obviously, our Arbitration Act has 965, which is the Local Arbitration Act, deals with local arbitration, has been amended by inserting the following provisions, which is very important. This act, which is the Arbitration Act 965, applies to any arbitration where the place of arbitration is in Fiji. And to that extent, International Arbitration Act 2017 does not apply. Okay. Upon commencement of the International Arbitration Act, for your note, our High Court rules has also been amended to set out procedures for seeking court order provided for in the International Arbitration Act. or Assembly 4 of the High Court rules sets down those procedures, the timeline and all. As you know, this is a very new act, came into force in 2018, December 2018. There has not been many cases in this regard in this court. There's only two. I've come across two cases. One is Centec New Zealand Fiji Limited and Fiji's Authority, which is, I won't say much about the case because that's before the Court of Appeal now, and from High Court to Court of Appeal. I think there's two cases, one by Centec against Fiji's Authority, one by Fiji's Authority against Centec. In one of them, the party has come and said that the arbitration clause, I think, and it was not in the dispute too, survives after termination of the contract. You can still use the arbitration clause if the contract has been terminated. Another one is the South Fertilizers Fiji Limited versus Allied Harvest International Private Limited. Brief facts of their case is as follows. Defendant supplies fertilizers to plaintiff from Hong Kong. Those fertilizers were not being released to plaintiff. Issue was payment of invoice that was in dispute. Court granted interim mandatory injunction for release of fertilizers. Defendant filed application for a stay of proceedings. In that, I think the court stayed the High Court proceeding because arbitration was conducted in Singapore International Arbitration Center, and the court granted. But the only thing I've made my observation when you read the judgment, just make a note of the fact what I said before about stay of court proceedings. I think in that matter, the High Court said that proceeding has to be stayed before you take action in the arbitration proceeding, which is not correct. Proceeding, you can apply for stay of proceeding, the High Court proceeding, before you take step in the court proceeding, not the arbitration proceeding. So that's just bear in mind when you read the judgment. Surely, arbitration process, as like any other process, that is found advantages and disadvantages. Generally recognized advantages are, as I've said, parties draw their own terms of reference for the tribunal and are liberty to appoint arbitrators themselves. Process is much faster than the court proceeding, we will know that. Hence, if the process is faster, you obviously save money and time. And you can, with that time, you can do something more valuable than running after the case, which parties definitely prefer. Awards have binding effect and can be enforced through the court system. When I said time and money, I mean the cost, legal cost, and that lawyers pay, the parties pay to lawyers. Disadvantages, except for applications outside the award on limited and specified grounds, no appeal lies against the award. Very limited grounds for appeal. Cost, if amount of money involved is not much, but issues are complicated, then cost may be an issue in arbitration proceedings too, but very rare though. Rules of evidence doesn't apply, so determined by the arbitrator. But we all know the advantages of having an alternate dispute resolution like arbitration and mediation outweighs the disadvantages that has been put forward. I've just quickly brushed through the International Arbitration Act. You'll obviously hear much more from the Honorable Justice Reyes and other presenters on the provisions of and working of the International Arbitration Act. I urge all of you to take active part in this workshop, and I wish you all an enjoyable workshop and a pleasant day. Thank you all for listening.
Honorable Chief Justice, thank you very much. I now have the pleasure of introducing Mr. Thomas Michael Clark, the General Counsel of the ADB, who will be addressing us briefly as well before the presentation proper starts. Mr. Clark holds a Doctor of Laws degree from Columbia University, where he was notes editor of the Columbia Law Review, and a Bachelor of Arts degree in government from Harvard University. He has over 30 years of experience in legal and government affairs practice, spanning the financial services, energy and infrastructure sectors. After judicial clerkship on the U.S. Court of Appeals for the D.C. Circuit and legal practice at the law firms of Sullivan and Cromwell in New York and Wilmer Hale in Washington, D.C., Mr. Clark joined the General Electric Company, one of the world's largest infrastructure and technology companies. His 22-year career at GE included 16 years based in Japan and covering the Asia-Pacific region as Geneva Counsel for GE's largest Asian financial services arm, and as Executive Counsel for Government Affairs and Policy, working with regulators and governments throughout the region on key legal and policy initiatives and holding leadership roles in industry associations and private sector advisory bodies for APAC and Asia. Most recently, Mr. Clark was Managing Director and Co-Head of Americas for the Global Public Policy Group of BlackRock Incorporation, the world's largest asset management firm, where he drove regulatory policy engagement and thought leadership on infrastructure finance, ESG and sustainability, disclosures related to climate risk and energy transition issues, data privacy, and fintech. As General Counsel at ADB, he is responsible for driving legal strategy and engagement on public policy reforms to support ADB's mission of achieving a sustainable, prosperous, inclusive, and resilient Asia-Pacific region. Mr. Thomas Clark, once again, I welcome you. A very good morning from the Fijian judiciary. And thank you for agreeing to join us. And I request you now to address the participants. Thank you very much.
Bula Vinaka, good morning. Lord Chief Justice Kumar, Your Ladyship, Madam Justice Wati, thank you very much for that kind introduction. Chief Registrar Leaj, and honorable members of the Fijian judiciary, and ladies and gentlemen. My name is Thomas Clark, and I'm the new General Counsel of the Asian Development Bank since the 1st of July of this year. And I am extremely honored to be here with all of you via Zoom, and I very much hope to meet you in person one day soon, when we have hopefully a very soon return to some normalcy. ADB is grateful for our excellent partnership with the Fijian judiciary, and we are pleased to convene the second Judicial Colloquium on International Arbitration, supported under ADB's regional technical assistance on the promotion of international arbitration reform for a better investment climate in the South Pacific. ADB has been Fiji's development partner since 1970, and we have been scaling up our assistance to Fiji and the rest of our Pacific developing member countries through sovereign and non-sovereign financing, policy advice, and targeted technical assistance. ADB's current country partnership strategy for Fiji over the 2019 to 2023 period focuses on encouraging private sector investment, improving service delivery and economic opportunities, and importantly, building resilience. As mentioned, private sector investment is critical for economic growth. And I thank the Chief Justice for his excellent comments, which I think recognize much of this. And it's important to focus on job creation in the South Pacific. In this regard, ADB is working with its Pacific developing member countries to improve the business environment, including ways to attract more and more foreign direct investment and cross-border trade, which has become even more vital given the need for COVID-19 recovery efforts. Alongside ADB's operations, My team, the Office of the General Counsel, manages a law and policy reform program in which we design technical assistance projects to work with our developing member countries and partnering with them. These projects are aimed at modernizing legal systems to encourage investment and trade, facilitate commercial activity, and to build the capacity of judicial and legal institutions, which are such a bedrock and foundation of a positive and attractive business environment. One major barrier, of course, in attracting foreign direct investment and stimulating this vital cross-border trade is the very lack of investor confidence in available, effective, and efficient ways to resolve commercial disputes between people from different countries. It's simply a fact that if capital doesn't have confidence that there will be an effective and reliable means of dispute resolution, it'll make a given place less attractive to invest that capital. Now, in recent decades, international arbitration has become the preferred means of resolving international commercial disputes all over the world. However, the South Pacific is still one of the few regions in the world, unfortunately, without a legal framework to resolve cross-border commercial disputes through international arbitration. So, to address this and assist our Pacific developing member countries to put in place an international arbitration legal framework, ADB launched a technical assistance project in the beginning of 2017. And I'm very happy to just talk a little bit about the fruits of that collaboration. For since 2017, there have been many positive developments, starting with Fiji's enactment of the International Arbitration Act in September of that very year, 2017. And I believe that Fiji's enactment of that act represents the most advanced state-of-the-art legislative framework for international arbitration in the region, certainly, if not the world. And it enhances Fiji's reputation as a place of international arbitration and business. Following Fiji's enactment of its International Arbitration Act, I am also very happy to report that Papua New Guinea, Palau, and Tonga have acceded to the New York Convention and currently are working on implementing arbitration bills of their own. Also, we have convened the first of its kind South Pacific International Arbitration Conference hosted by the Fijian government, and the second South Pacific International Arbitration Conference hosted by the Papua New Guinea government to raise awareness about this importance, the importance of the reforms to the South Pacific region, as well as we've delivered numerous capacity building programs to judges, to lawyers, and to the private sector over the last 3 years. And looking forward, in March of 2021, we will convene the third South Pacific International Arbitration Conference. And in that regard, we very much look forward to your participation. The Fijian judiciary plays a key role in the effective implementation of the International Arbitration Act. So we are very grateful to the Fijian Supreme Court for making today's judicial colloquium possible. Recognizing the judiciary's important role in key areas of the law, especially with significant development outcomes, I am pleased to announce the launch of a new regional technical assistance program early next year to provide sustained support to judiciaries in our developing member countries in the adjudication of commercial and environmental and climate change disputes. This is obviously a very timely topic, and under this new technical assistance, ADB will assist through the delivery of tailored capacity building programs, such as this colloquium that we're participating in today, and development of specialized knowledge resources, as well as the convening of regional conferences to promote judicial dialogue, best practice and knowledge sharing, and cooperation. ADB will also launch another regional technical assistance early next year to support judiciaries in our Pacific developing member countries on another very important topic, I think very important to many of us, as we think about the future of the region, and that is the adjudication of gender-based violence cases to better address the needs of women survivors of violence. This technical assistance will provide customized trainings for judges and prosecutors on gender sensitization, on violence against women laws and procedure, and develop tools such as benchmarks, protocols, guidelines, various books to assist in the handling of violence against women cases. We hope to engage with the Fijian judiciary in all of these important areas, and we look forward to continuing our great partnership. I would like to extend my sincere thanks to all of you for taking the time out of your very busy schedules to be here today and to learn more about international arbitration and the implementation of the Fiji International Arbitration Act. We are also privileged to have 5 eminent international arbitration experts to serve as trainers today. And I would like to extend my sincere gratitude to Justice Anselmo Reyes, Daniel Meltz, Brenda Horgan, Joe Delaney, and Jonathan Lim. I very much am sorry that I am talking to you today only over Zoom. And while I appreciate the benefits of technology, I regret that we are not able to have the in-person chance to meet and get to know one another better and to enjoy the kind of camaraderie that only comes in person. However, I hope the day will come very soon when we will be able to meet in person. And until that day, and for the course of this session, I leave you in their very capable hands. And I thank you again for your participation today, and I wish you a very successful colloquium. Thank you very much.
Mr. Clark, thank you very much for your address, and thank you to the ADB as well for funding the workshop. We will now at this stage have the photo session for all of us present here, after which we'll then cross over to Mr. Daniel Maltz to then introduce us the speakers and for the program proper to start. So we'll ask all the participants to come forward in this room for the photo session, please.
Hello, and thank you very much, Acting Lord Chief Justice, for those opening remarks, and also to you too, Justice Watty, and to the ADB team in Suva and elsewhere who've organised this. My name is Daniel Meltz, and I will be familiar to some of you because this is our second training session for the judiciary of Fiji. As General Counsel of the ADB mentioned, Fiji was one of the first, was in fact the first mover in the South Pacific for this technical assistance project in enacting its International Arbitration Act in 2017. Fiji had already acceded to the New York Convention in 2010, but was a very early adopter of this legislation. And we know both from judgments and from material before the court now that the material cases have already started. There are already judgments, and that is a very positive sign. In terms of today, the format is that there is a problem that you've been provided for already, and that will be introduced by Justice Reyes shortly. I have the pleasure of introducing the training team today. That includes principally Justice Reyes, who is an experienced judge, arbitrator, counsel, and academic in the field of international arbitration. Justice Reyes currently sits as a judge of the Singapore International Commercial Court, but he has many years' experience on the bench in Hong Kong, and in particular running the international arbitration list there. The other people joining us to train today are also familiar in Fiji. First of all, Brenda Horrigan. Brenda is a partner at Herbert Smith Freehills in the Sydney office, and she also is the president of AKICA, which is the principal Australian international arbitration body. Jo Delaney is a partner in Baker and McKenzie, again in the Sydney office. She has a breadth of experience in London and in Sydney in international arbitration. And she is one of the early pioneers, if you like, of investment treaty arbitration in particular. We're also joined by Jonathan Lim. Jonathan is a partner, a senior counsel at Wilmer Hale and works in the arbitration group there with Gary Bourne, who is the co-consultant to the ADB, together with myself, on this arbitration project. Gary Bourne's group and the work that Johnny does is some of the most significant arbitrations that take place. And Johnny has made an enormous contribution to the drafting and assisting the drafting of the Fijian Act along the way as well. And we thank him. In terms of how we're going to proceed today, as I mentioned, Justice Reyes will introduce the problem in a moment. We'll then break out into the group sessions, and you've all been allocated group sessions. In terms of the actual study, each of you will have a convener of one of the trainers who will assist, and then we'll all come back in plenary session and discuss the problem from there. So without further ado, I'd like to introduce Justice Reyes to talk about the problem today.
Thank you very much. Chief Justice, fellow judges, distinguished guests, ladies and gentlemen. I'd like to thank the Fiji Court for inviting me to address it this morning. It is a daunting experience for anyone, for counsel, for a judge, to address not only a Chief Justice, but a whole room of judges. Accordingly, I propose to be short and to get right to the point. In fact, I will make only 2 points. The first point is mundane. It is purely administrative. The second point is more practical. Let me start with the mundane point. Daniel has said that I will introduce the problem. The problem is relatively straightforward. It relates to a Fiji company, IPO, that enters into a main construction contract with a PRC company, a Chinese company, Legend, and Legend enters into a subcontract, a construction subcontract, with a Thai company. The subcontract provides for the terms to be on a back-to-back basis with those terms in the main contract. And the main contract has a dispute resolution clause which provides for arbitration before the Hong Kong International Arbitration Center, the HKIAC. And various scenarios are raised in the case study which we will deal with. We will deal first in this morning session with the questions 1 and 2, and in the afternoon session with questions 3 and 4. The questions 1 and 2 for this morning deal with two of the most common situations that arise requiring judicial support of international commercial arbitration. The first question has to do with stay of proceedings in favor of arbitration, and the second has to do with interim measures. I believe that the Fiji court has already encountered situations of both types since the passing of the International Arbitration Act. By way of administration logistics, we will, after the After the breakout sessions, we'll be shortly going into breakout sessions, we will reconvene for a plenary session to discuss, to get input from the questions. And what I've proposed is that Group A will give a short report. Someone from Group A will speak quickly, about 10 minutes, on the approach to sub-questions 1 and 2 of question 1. Group B, someone will be designated from Group B to speak quickly, 10 minutes, on the approach to sub-questions 3 and 4 of question 1. And then a person will be designated in Group C to address sub-question 5 of question 1. Finally, question 2, someone will be designated from Group D to address sub-questions 1 and 2. And then we will have a few minutes for discussion and wrap-up of this morning's session. We're running a little late, so we may have to abbreviate the times. I will suggest a way to do that at the end of my small presentation. That's the practical administrative point. Let me now go on to the more practical theoretical point, shall we say. And that is this. As a judge trying to handle international commercial arbitration cases, I was assigned, when I was a judge in Hong Kong, to handle the arbitration list. I did so for 4 years, from 2004 to 2008. Now, when I was thrown into the arbitration list, I had not really had that much experience of international commercial arbitration. I had had some experience as counsel, but I hadn't really had a chance to think about the theories and the practicalities of international commercial arbitration. And as a judge, I was looking for some principles that I could hang on to and use them as guidance, as brief practical points that I would always go back to whenever I was faced with an international commercial arbitration problem. And these are the key principles that I gleaned from the Hong Kong equivalent of the Fiji International Arbitration Act. The Chief Justice a moment ago mentioned the arbitration ordinance in Hong Kong, and we have very, very similar principles. These are the principles that I gleaned, and I'm going to run through them very quickly, and I hope that they will also provide, at least based on my experience, they will provide some guidance for you, some points that you can always come back to in difficult questions and use these principles to analyze, to find a way out, or to find a way to resolve the issues before you. I've put down on the left, I'm sharing my screen at the moment, I've put down on the left column the sections from the Fiji International Act where I've drawn the principles from, and on the right, I've used my own words to describe what I believe the principle to be. The first principle is, if you are stuck, you can seek assistance from international principles and practice in relation to the model law. Many cases, international decisions relating to the model law, the UNCITRAL model law in international commercial arbitration, and the New York Convention are found or may be easily accessed through the internet. So when stuck, I look at international principles and practice, and I try to conform with international principles and practice. Secondly, there's a principle of good faith. We must assume that the parties in engaging in arbitration are acting in good faith and wish to observe good faith. And that should guide how we resolve problems. We assume or presume that the parties wish to act in good faith. The third principle is party autonomy. We can, to the extent possible, unless there's something contrary to public policy, give effect to what the parties have agreed. The parties have agreed in an international commercial context to have their disputes resolved through arbitration. To the extent possible, we should give effect to that on the principle of party autonomy. The next principle is very important, and it comes from Section 8 of the International Arbitration Act in Fiji. That's minimal interference. It's a corollary to the principle of party autonomy that I just described. The judiciary should only interfere minimally, only as provided in the International Arbitration Act. As much as possible, the parties should be left to resolve their disputes in accordance with their agreement. Section 7 is an interesting principle. It's a principle of waiver. Where parties take part in arbitration proceedings and do not raise an objection in the whole of those proceedings, a procedural objection, then they really shouldn't be allowed to raise that objection later on. If there's some sort of irregularity that the parties would or ought to have known, but they've taken part freely in the arbitration right to the end and have not raised any objection, then they should be deemed to have waived that objection. Section 22 of the Fiji International Arbitration Act gives rise to two important principles, that is competence, and the independence of the arbitration agreement from the rest of the contract, what's sometimes called separability. The arbitral tribunal is competent, has the competence to determine its own competence. That's the principle of competence. The arbitral tribunal can determine its own jurisdiction. The arbitration agreement is separate, is independent from the contract in which it may be embedded, such that even if the main contract, the rest of the contract, is invalid or void for some reason, the arbitration agreement may still be valid. So these are two important principles, and over and over and over again, they come back, and they are a convenient way of analyzing apparently intractable arbitration problems. The next principle that I gleaned from the International Arbitration Act and from Hong Kong's arbitration ordinance, and that has guided me, is that the tribunal's ruling, the arbitral tribunal's ruling as to jurisdiction, is not the final word. As the Chief Justice pointed out a moment ago, there are 30 days in which an unhappy party, typically the respondent, may appeal to the court against the tribunal's ruling that it has jurisdiction. So there's the principle of competence. The tribunal is competent to determine its own competence, that is, whether it has jurisdiction, whether it has power to hear a case, but the tribunal's ruling is not final. The final principle that I've found useful is this: the court has concurrent power to order interim measures, including any order to a party to, quote, take action that would prevent or refrain from taking action that is likely to cause current or imminent harm or prejudice to the arbitral process itself. I've taken that definition from the International Arbitration Act, Section 23(2)(b. The court has concurrent power to grant interim measures in support of arbitration. Now, I note an important qualification that apart from sections 12, 14, 31, 32, 33, 53, 54, and 55, the provisions of the International Arbitration Act only apply if the place of arbitration, if the seat of arbitration is in Fiji. Now, we'll see the possible ramifications of that in the course of our discussions today, but the principal sections that we'll be focusing on, in particular 12, 14, 31, 32, 33, 54, all of these relate to, or can relate to, arbitrations that have a seat outside of Fiji. There, in summary, are the principles that I always come back to. It's easily summarized, these principles, but together, their interaction, I think they can provide a key to the resolution of problems, seemingly difficult problems in international commercial arbitration. Now, I've said that we're running short of time. I'm going to stop there. I suggest we have 45 minutes for our discussions of questions 1 and 2 in the breakout rooms. Our tea break is scheduled for 11 o'clock Fiji time, from 11 to 11:15. I respectfully submit that we can take 45 minutes to discuss and take the tea break a little later from 11:15 to 11:30. But that is my respectful submission. I look forward to our discussions. Thank you. It would help if you're not speaking to keep your video on mute. Apparently, some of the problems that we encountered this morning may have been due to sound feedback through too many videos being left unmuted. So If you're not speaking, please put your video on mute. The same goes during the breakout sessions. For the questions in this part, questions 3 and 4, the distribution, when we go back into plenary session in a moment, after the breakout sessions, will be as follows. I won't read it out. They appear on page. They appear in my key principles that have been distributed to you. Which group is going to speak or invited to speak on which sub-questions of which main question. I thought I might just spend a few minutes before we go into breakout rooms talking about recourse, applications to set aside an arbitration award, and applications for the recognition and enforcement of a foreign arbitral award. That is, focusing on International Arbitration Act, sections 52 and 54. These are some of the key applications that a judge handling international commercial arbitrations is likely to encounter. First, what's the difference between setting aside an application to set aside an arbitral award, sometimes referred to as a recourse against an arbitral award, and an application for the recognition and enforcement of an award? Typically, you apply to set aside an award in the court of the seat of arbitration. The seat of arbitration is that jurisdiction which has supervision over a particular arbitration. So typically, the law of the seat, if the seat were Fiji, the International Arbitration Act in relation to international commercial arbitrations, the arbitration law of the seat governs the arbitration proceedings. Bear in mind, that's different from saying the governing law of the arbitration agreement. This is simply the law that governs the arbitration proceedings. The law of the seat of the arbitration will govern typically the arbitration proceedings. So you apply to set aside recourse against an award in the court of the seat of arbitration. You apply for the recognition and enforcement of an award, or you apply to resist recognition and enforcement in a jurisdiction where the arbitration award is sought to be enforced. Now, I keep saying recognition and enforcement. Is that a pleonasm? What's the difference between recognition and enforcement? Typically, in order to enforce an award, a court in an enforcing jurisdiction would have to recognize the award in the first place, and then it can be enforced. Execution can be levied in terms of the award once converted into a judgment of the court. But it is not always the case that one applies for enforcement of an award. One may simply want to have an award or some aspect of the award recognized. For instance, for the purposes of creating a res judicata or an issue estoppel. So recognition and enforcement, although they are overlapping concepts, are not necessarily the same thing. Recognition and enforcement, when Fiji is the enforcing state, when someone is seeking to enforce an award against a foreign award against assets in Fiji, for example, would be governed by Section 54 of the International Arbitration Act. If Fiji is the seat of the arbitration, the supervising jurisdiction for the arbitration, the jurisdiction whose arbitral law, for instance, the International Arbitration Act, governs the arbitration procedure, then if Fiji is such a place, then an application may be made to the Fiji court for the setting aside of the award. The seat of the arbitration for the setting aside of the award or recourse against the award, the International Arbitration Act, Section 52, is directly analogous to the provisions in the model law, the UNCITRAL model law on international commercial arbitration. The Section 54 on recognition and enforcement, Section 54 is analogous to the provisions in Article 5.1a and Article 5.1b of the New York Convention. I note that both the model law and the New York Convention set out limited grounds for setting aside or refusing recognition and enforcement of an award, as the case may be. Simply because those grounds are met, if a party is able to show that one or other of those grounds have been met, it doesn't automatically follow that an award is set aside or that an award is refused recognition and enforcement. There still is a discretionary element left to the court. Notice the wording in IAA sections 52 and 54. The court may set aside. The court may refuse recognition and enforcement if one or more of certain conditions are present. But it is still a discretionary remedy. And it is not necessarily all or nothing. Let us say simply because one of the grounds in section 52 or one of the grounds in section 54 has been established, it doesn't necessarily mean that all of the award is refused, is set aside, or all of the award is refused recognition and enforcement. It may be that some parts of the award, which are not vitiated by the problem, the condition found, can go on, can be enforced, need not be set aside. Other parts of the award may have to be set aside or refused recognition and enforcement, as the case may be. The grounds for setting aside an award under IAA Section 52 and the grounds for refusing recognition and enforcement under IAA Section 54 are similar but not identical. Roughly, the grounds are, the Chief Justice identified them this morning, but just by way of summary, they are a lack of capacity, a lack of due process, insufficient notice, no reasonable opportunity to present one's case, a lack of jurisdiction on the part of the tribunal, an improper constitution of the tribunal, it's not constituted in accordance with the parties' agreement, a lack of finality, an appeal against the award is pending. These are the essential grounds from which for setting aside or refusing recognition and enforcement. There are two additional grounds under sections 52 and section 54. Those are lack of arbitrability, something is not arbitrable, and something is contrary to public policy. But note, under section 52, setting aside, something is not arbitrable under the law of Fiji, as, let us say, the seat of the arbitration. Something is contrary to the public policy of Fiji as the seat of the arbitration. When we go to refusing recognition and enforcement, the lack of arbitrability and the contrary to public policy grounds are slightly different. Look at the enforcing state. Is there a lack of arbitrability under the law of the enforcing state? Is there something contrary to public policy under the law of the enforcing state? So if Fiji is the enforcing state, let us say Hong Kong, the award was obtained in Hong Kong, the question would be, is there a lack of arbitrability of the subject matter of the award under Fiji law? Is there something contrary to public policy in respect of the award under Fiji public policy, if Fiji is the enforcing state? The public policy test is a very narrow one, and I think you're all familiar with that from the first arbitrations colloquium that ADB had in Fiji. You can only set aside for public policy where something is contrary to the fundamental legal norms, moral, cultural, social norms of a particular jurisdiction. So it's a very, very narrow test. Nowadays, most parties try to have an award set aside or refused recognition and enforcement under a very different ground. They tend to say that they had no reasonable opportunity to present one's case. In other words, a lack of due process. The final point to note, perhaps, in this brief summary of the law of setting aside and the law of refusing recognition and enforcement is the distinction between active and passive remedies. Consider this. Supposing a respondent loses an arbitration. The respondent does not apply to set aside the award in the seat of arbitration. Let's say the seat of arbitration is Hong Kong. Can the respondent resist recognition and enforcement in an enforcing state, let's say in Fiji? I haven't bothered to apply to set aside an award, to have recourse against an award in Hong Kong, the seat of the arbitration. Can I resist recognition and enforcement in the enforcing state? Under the New York Convention, it seems from the travaux préparatoires, from the documents leading up to the creation of the New York Convention, the answer is yes. The respondent can resist recognition and enforcement. Seeking recourse, applying to set aside, is an active remedy. Resisting recognition and enforcement is a passive remedy. Under the New York Convention, there is no bar to simply seeking a passive remedy. A respondent can say to a successful claimant, come and get me, come to my home jurisdiction or whatever jurisdiction where my assets are and try to enforce against my assets here. I will resist you. There is no obligation on a respondent and a losing party to apply to set aside an award in the seat to exercise the active remedy. But let's make it more complicated. The respondent actually applies to set aside the award in the seat, makes use of the active remedy, but fails. The respondent fails. Can the respondent raise the same grounds in an enforcing state? Or is there res judicata, or is there issue estoppel? Can the respondent raise different grounds, grounds that the respondent could have raised when the respondent applied to set aside the award, but failed to do so? Is there, in common law jurisdictions, it's known as Henderson and Henderson estoppel. You cannot normally, in common law principle, raise grounds that you ought to have raised in a proceeding, but failed to do so. You have only one chance at it. You don't get a second bite at the cherry. But what's the position in international commercial arbitration? And then finally, look at this situation. The respondent applies to set aside the award in the seat of arbitration and succeeds. Can the claimant nonetheless seek to enforce the award in an enforcing state? Let us say the seat of arbitration is Hong Kong. The respondent applies to set aside an award against the respondent before the Hong Kong court and succeeds. The award is set aside. What happens then? Can the claimant still enforce the award against the respondent's assets, for instance, in Fiji? These are all controversial questions. There's no easy answer to them. It's not always clear how the doctrines of issue estoppel and res judicata come into play. These are food for thought. We can explore these in the course of the plenary session if you're interested. But for now, I think that is enough for these few minutes of introduction, and I think we can move now into the breakout rooms. Please remember, if you're not speaking, to keep your mute on, and please bear in mind that certain groups are allocated to certain sub-questions of the questions. Thank you very much. I think I'll start now. Let me just wait for the signal from Daniel. Is that all right, Daniel? The Master of Ceremonies? Daniel is nodding. All right. I'd like first, at the start, to thank Joe and Brenda, because I understand that due to other commitments, they will have to leave shortly to meet their other commitments. I understand that Jonathan will be leaving in about 45 minutes. Questions to ask Jonathan. They ask the questions now while they're still with us. Looks so young, but we mustn't be deceived by his youthful looks. And so we must tap into his experience now while he's here. Brenda and Joe are going to leave very shortly, so we must tap into them. They've been given an easy time so far, so we need to give them a rougher time, ask them some questions. So if you have any questions for Brenda, Joe, or Jonathan, now's the time to ask. So just speak up, unmute yourself and speak up and shout out your question. There appears to be...
Yes, no, I had a question. I was interested in the issue of on an application to set aside a statutory demand for
I'm afraid I've lost the question after. I was interested in the application to set aside a statutory demand. Could you repeat the question, please? First, could you identify who you are? Because I'm desperately looking amongst the to try to identify.
It's Alan Stewart. And my question was on an application to set aside a statutory demand where the court is being asked to defer to an arbitrator because the parties are parties to an arbitration agreement. Should the court defer to an arbitrator to leave that issue to be decided by the arbitrator, or should a court decide whether to set aside the statutory demand because it's satisfied that there is a genuine dispute or not, as the case may be?
This is a very hot question. Joe, what's your view on this?
So the statutory demand process is a little bit different and doesn't come up very often in arbitration. It's used in court proceedings, but not so much in arbitration. So I think it's a little bit more challenging to see it in that context. Have you come across it, Daniel, in arbitration, or have you seen the interplay between the two?
I haven't come across it in arbitration, but certainly that is not an easy question. And it touches on the question as to whether insolvency proceedings generally are quarantined from arbitration proceedings, or whether there is some sort of interplay between the two. There have been a number of Australian cases that have considered that. The name of it escapes me at the moment, but I know that issue has been considered. In the context of a statutory demand particularly, the issue always arises as two issues arise. First, is there a genuine dispute as to the demand? If there is a genuine dispute, is that dispute in fact covered under the arbitration clause and pursuant to the arbitration agreement? That in turn raises the issue as to whether a court needs to ensure that all disputes are submitted, are stayed in favour of arbitration, or in fact the court will hive off some aspect of a claim on the grounds that that process, the statutory demand process, for example, is not covered under an arbitration agreement as to any dispute arising thereunder, and therefore would be prepared to do that. But it's not a particularly easy or definite answer that I can give.
I suppose just to add to that, Daniel, you could say that the statutory demand process is really just enforcing a debt under the contract. So if there is a debt under the contract, that there was a payment that was meant to be made, you can issue a statutory demand so that to demand that you get that payment with a certain period of time. And then if they don't make the payment, you can proceed down the insolvency path. So if they don't make the payment, you could continue down the insolvency path. But if they dispute the payment, then I could see why a court would say this dispute needs to be referred to arbitration if there is an arbitration clause in the underlying contract. So I suppose it depends on how the debtor responds to the statutory demand, because usually the point of the statutory demand is to force them to pay because they've delayed, or to force them to go into some sort of insolvency process.
Jonathan, do you have any comments you'd like to add? Because there's a Singapore decision, a decision appeal.
Yeah, I haven't looked closely at the decision recently. I don't really have that much to add at this point.
There are a variety of approaches in different jurisdictions. Singapore takes the approach, which I think is the correct one. I personally think is the correct one. That is, if there is an arbitration agreement, and if someone claims that there are genuine grounds to dispute the statutory demand, then that matter must go to arbitration. It's not for the court to determine whether there are genuine grounds. That is the Singapore position. The Hong Kong position is different. As a result of the decision of one of my former pupils sitting as a deputy high court judge. He thought, statutory demand is part of insolvency proceedings. Insolvency proceedings have a public element and have nothing to do with the private element that is present in arbitration. And therefore, he thought, the arbitration agreement is trumped by, maybe disregarded as a result of, the insolvency proceedings. I'm not sure his analysis is correct, but anyway, that seems to be the position in which the Hong Kong court is leaning. I don't believe, as of yet, there is a clear-cut Court of Appeal decision in Hong Kong that has illuminated this, but this is a question that is very hot because, as Daniel pointed out, and as Joe has pointed out as well, there are various conflicting decisions in various jurisdictions. My own take is this: when you have a statutory demand, when you petition for a bankruptcy or insolvency as a result of a statutory demand, if there's a problem with your petition because there is an arbitration agreement, then your petition, I think, shouldn't go forward. Your petition must be dismissed because you have to go to arbitration to determine whether there is or is not a genuine dispute and how the dispute should be resolved, if there is one. Nonetheless, the public element comes in because when a petition is dismissed, a co-petition, someone else who is petitioning, another creditor, is allowed to step into the shoes of the petitioner and say, all right, that petition is knocked out, but my debt can replace that, and I will step into the shoes as as another petitioner. So there is always an option for someone else to step in the shoes. If there's only one petitioner, if it's only the person who has a statutory demand which is subject to an arbitration agreement, there's no other debtor in place, then it seems to me, contrary to my pupil's analysis, I don't really see what the problem is about staying proceedings to determine this one demand. If there are other creditors ready to step in and take over the petition, well then the debtor has more problems, and it's really for the debtor to deal with those petitioners under the insolvency mechanism. So I think one has to keep the two lines clear, but that's my take. I don't know if that has answered your question, Justice Stewart. It seems like you must choose your own.
Yeah, well, it's a fascinating topic. I think probably more fascinating if you think about the situation where there isn't a genuine dispute, but the debtor company is able to defer the proceedings by referring it to arbitration in a way they wouldn't be if the matter were dealt with by the court.
Certainly, that is likely to happen. Again, I fall back to the principle party. Are there other questions while Jonathan is still with us? All right. In that case, Jonathan is still with us a little bit longer, but let's go ahead with our presentations. Perhaps someone in Group A, either Master Bull or Justice Amaratunga, can speak to sub-questions 1 and 2 of question 3. Just a taste of our discussion in Group A on those questions. Who would like to do it? Master Bull or Justice Amaratunga?
With Justice Amaratunga, sir.
All right. Justice Amaratunga, would you like to say a few words?
Justice Amaratunga, you're on mute.
Justice Amaratunga, you're still on mute. You have to unmute yourself. We seem to be encountering technical problems with Justice Amaratunga. it doesn't seem like he's. Can you unmute yourself, Justice Amaratunga? I'm afraid I'm not able to translate.
Arbitration is held in Fiji, it should be held in Hong Kong.
Can you hear the
application to stay in Fiji?
Yes, the first question is, can you hear the legend's application?
For stay in Fiji.
The thing is, we can hear this application. Because first thing is, any application made to court, we have to hear. The courts are there to give a hearing to a party. Second question is, should you hear the application? That also the answer should be that since they have come within the time, this application can be heard.
Is there anything else you'd like to say, Justice Amaratunga?
You can't hear it in Fiji. That's what I'm trying to say. Because there's it should have the Fiji jurisdiction for here in Fiji. Therefore, can they hear it? Exceeded jurisdiction of using the seat of arbitration in Fiji to Hong Kong.
Perhaps in the interest of time, as we don't have too much time, I'll just fill in a little bit more on what Justice Amaratunga says. Justice, thank you very much. Let me just make one point. However you want to answer this question about whether the tribunal's order that Fiji, rather than Hong Kong, is the seat of the arbitration, however you want to rule on that as a question of jurisdiction or not, perhaps one thing that you might want to bear in mind is that nowadays parties are becoming very clever in the ways that they are challenging arbitration awards. And there is a tendency nowadays to turn lots of things that you wouldn't think are jurisdictional questions into jurisdictional questions. I gave an example in my group, Group A, about a question of whether something is outside the limitation period. I believe there was a recent case before the Singapore court. You say this arbitral tribunal has no jurisdiction because the arbitral proceedings were brought outside the limitation period. The arbitral tribunal decides that the proceedings are within the limitation period. The challenge is brought, this is outside the arbitral tribunal's jurisdiction because they had no jurisdiction as the limitation period had already expired. Now, is that a jurisdictional question, or is that just some sort of question as to whether a proceeding, a claim, is or is not admissible because it is out of time? It's not really a matter of jurisdiction, but simply a question of admissibility. Now, the Singapore court dealt with that question about limitation as saying it is a matter of admissibility. But if you think about it, lots of questions that might not seem on their face to be jurisdictional questions can be transformed into jurisdictional questions and means of challenging an award. So you'll encounter this. This is the wave of the future, and you may have to try to articulate what is or is not a true jurisdictional question. I'm not sure we can do that today. It's a very difficult and complicated question, but it's something to bear in mind. Not everything is a jurisdictional question, and one has to be careful not to be taken in by arguments that something is a jurisdictional question when really it's something else. So that was the gist of our discussion on this question. I wonder now if someone would like to take over from question 4, someone from Group B. Would someone be able to speak to that? Anyone from Group B who would be able to speak on question 4, on sub-question 1 of question 4? Is there anyone from Group B? I'm afraid Brenda is no longer here. So has anyone been designated in relation to question 4.1 from Group B? If so, just speak up. Just unmute yourself. Don't forget to unmute yourself and please speak up.
Yeah, let's say extension of time, whether the court has power to extend of time. So during our discussion, we have decided the court has no jurisdiction to extend the time for setting aside application. It may not be made outside the limitation period of 3 months. So 3 months is a mandatory provision. So therefore, we have decided the court will not extend the time for setting aside the application. Yeah, we'll refuse that application.
Thank you very much, Justice Ashmir. This is, again, proving to be a controversial question. A number of jurisdictions have agreed with Justice Ashmir that there is no jurisdiction to increase the time. In particular, attention has been drawn to similar provisions to Section 8 of the Fiji International Arbitration Act, which says you can only interfere as a court to the extent authorized by the Act. Now, where in the Act is there any provision that says you can extend the time imposed by the Act? There doesn't seem to be any. So that in many jurisdictions following the model law, like Fiji, courts have concluded there is no jurisdiction to extend the time for applications to set aside. However, there is no uniformity, I'm afraid, amongst model law jurisdictions on this point. Hong Kong, a judgment of Justice Mimi Chan at first instance, has held that there is jurisdiction to extend the time. Now, I have queried her reasoning in one of my Singapore judgments. Her reasoning goes something like this. Her reasoning, she latches on the words that an application to set aside may not be brought. And she says, well, you may do something or you may not do something. That's permissive. So you may not be, that doesn't mean the same thing as ought not to be brought. Now, I think that's wrong, but that's what she said in terms of her linguistic analysis. Secondly, she derived some support from the rules of the High Court. The rules of the High Court in Hong Kong are almost identical to the rules of the High Court in Fiji. And you know very well that the rules of the High Court in Fiji, as well as in Hong Kong, allow the court to extend the time, extend deadlines. But those are only procedural deadlines. But she seemed to think that the rules of court, secondary legislation, allowed her to extend the time in primary legislation. So that's my difficulty with her analysis there. But the Hong Kong court says this, you can extend the time, and Malaysia, curiously, has a sort of what you might call bipolar attitude to this. The High Court of Malaysia routinely says you cannot extend the time. But the highest court in Malaysia, the federal court, has one decision where they have said you can extend the time. Now, it's not clear how exactly the federal court and the high court see things. They don't seem to see eye to eye on this matter, but that's one of the mysteries about Malaysian jurisprudence on this point. So there are some interesting ramifications. Many jurisdictions say you cannot extend the time. Some jurisdictions say you can. All right, let's move on to sub-question 2 of question 4. Anyone from Group C would like to speak up?
Yeah. Yes, I'm the lucky person chosen to speak on this. We felt that the starting point for this issue was Section 34 of the Act, which requires that the parties be treated with equality, and each party shall be given a full opportunity of presenting his or her case. But apart from that starting point, we thought that the issue was going to be very fact dependent. For example, on were both parties affected equally by these issues with the video link, or was one party, for example, conducting its case in face-to-face with the arbitrator, while the other party had to deal via Zoom. So the issue really boiled down to whether both parties were given an equal opportunity, and whether there was in some way a breach of natural justice in the way that the technical issues affected the way that they were able to present their case. Joe, our moderator, referred us to cases that suggest that there was a very high standard for establishing that there was a breach of natural justice, and the courts would look to see whether there was some real practical injustice to the party as a result of these sorts of difficulties before it would consider setting aside or declining to enforce the award.
Thank you very much. Thank you. That's very helpful. We also agreed in our group that it was a fact-dependent situation. So it all depends on the facts of this case. And as Mr. Justice Stewart has identified, there is a high threshold. You have to establish that there's some sort of unfairness, some sort of impediment to your being able to present the case. But if you look at the web nowadays, there's no shortage of webinars where you have speakers coming up and saying in international arbitration, you are entitled to a face-to-face hearing for whatever reason, so you can confront the other side in cross-examination. And if you are not given a face-to-face hearing, if it's only a remote hearing, it's not the same thing, and therefore you are denied, by that fact alone, you are denied a reasonable opportunity to be heard, and therefore the award is capable of being set aside or refused recognition and enforcement. I don't think that there is one easy, short answer to this. One size fits all. As Mr. Justice Stewart says, you've got to look at the facts of each particular case. And I understand from the Chief Justice that even in litigation in Fiji nowadays, you have the same question cropping up, because a lot of litigation is now being conducted through remote technology such as Skype in Fiji. That our court, my court, the Singapore International Commercial Court, is also faced with the same sort of complaints from time to time. You have parties insisting that they want to be physically present. Now, this can be used as a delaying device, because who knows when COVID-19 will go away? Who knows when travel restrictions or quarantine restrictions all over the world will go away? Even with a vaccine, some places may still be subject to travel restrictions. Some places may still be restricted to quarantine. There may be difficulties traveling in any event. So if one says, as a general rule, that face-to-face hearings are the norm, then there could be a lot of delay to international commercial litigation, international commercial arbitration, so there would be problems. So it's again, as usual, a balancing exercise that the court has to do, and one that is fact sensitive. Daniel, do you have any comments from your own experience as a practitioner?
Yes, I do. What I'm finding, just in terms of the bigger picture, is that in terms of challenges to enforcement, this has probably become one of the most popular avenues that parties attempt now. And there's a large range of opportunity to be heard, cases that come. Some, for example, emanate from the hearing itself, where parties are given sometimes a 50-50 split of time, but then it transpires that during the hearing, it ends up being 60-40 or 70-30, and one party feels aggrieved and therefore wishes to challenge on that basis. So the bigger picture is that this has become a popular avenue for challenge on various grounds. In terms of the dealing with the facts of this matter, yes, this has been very difficult, because there have been circumstances that have come about where, for example, on video link, particularly of witnesses who are remote, that there has been instances of people who've either had notes or prompts in the witness boxes. There have been instances of people who've had other persons in the room who have been able to, during breaks, talk to people, notwithstanding that they've been cautioned. So there are legitimate issues that can be raised by way of these remote hearings. We in Sydney still are operating in many of the courts, particularly in the commercial division, on a Zoom basis. And yes, there are interruptions, there are difficulties sometimes, and the parties, if that difficulty is truly substantial, particularly in arbitration where people are spread around the world. Particularly another matter that arises in arbitrations is that the people are in many jurisdictions, and there are very difficult time zone scheduling issues. So a witness may have to give evidence at 2 a.m. their time. Is that a reasonable thing? So these are all the matters that I've seen come up on this point.
Jonathan, do you want to add anything based on your experience?
Just a few short points, I think. I think the first is that it is right, I think, that this has become a popular ground for attempting to set aside an award. And you'll see in some decisions, there's judges are becoming conscious that this has become an avenue for what's called a backdoor appeal in many ways, because it is possible to frame most unhappiness about the result of a decision as an unhappiness over not being accorded enough due process and able to make the argument about the issue that has led to the decision. And so you will see this as quite a common challenge. I think that's the first comment. I agree the threshold is high, obviously, and I think one other thing that emerges from the jurisprudence is also a need for some kind of causal nexus between the complaint, right? So they can't just be a breach of due process. It would have had the result in the making of the award. And so you can't just allege any sort of due process in a way that's peripheral or trivial. It's got to relate to the outcome. And I think those are important protections there to ensure that judges don't overzealously, I guess, police due process to the point that it hampers arbitrators' ability to manage the process, because sometimes these challenges come in when evidence is sought to be put in late by a party, sort of the eve of a hearing, and the arbitrator decides not to admit that evidence, and, is that a breach of due process? Is that one party not being allowed to present its case? It can certainly be framed that way. And I think courts in general are very conscious of allowing due process type challenges to become a backdoor appeal. I think that's the comment I would add. And on Zoom in particular, Zoom hearings in particular, I would just note that I think a lot of arbitration rules give tribunals a broad scope of discretion to decide how to order a hearing and whether to hold it by video conference. I think that should be taken into account as well. I think the fact that the parties have given the tribunal such broad powers.
Now let's move to your group, Jonathan, Group D. Has someone been designated to speak on sub-question 3 of question 4?
Yes, I think Master Azhar has been volunteered by the group.
Master Azhar has volunteered, has he? By the group, you say?
Yes.
Master Azhar?
Actually not volunteered, forced to volunteer.
Well, thank you for volunteering.
Question 3.
3, A, B, and C, isn't it?
Yes.
Yes.
Yes. So the question is that the Thai company is trying to set aside the award in Fiji on the basis of public policy for the reason that the tribunal has awarded the compound interest. Yes, the question is that the Thai company is applying to set aside the award in Fiji on the basis of public policy that the tribunal awarded the compound interest in the case. So the first question is, how would you decide the application? Assume that the arbitral tribunal found that Fijian law was the governing law of the subcontract. So if you look at the sections in the Fijian International Arbitration Act that is relating to the setting aside on the ground of public policy, section 52 to B2 is the applicable section. In addition, the general provision under section 54 1A B2 also applicable. So if you look at both sections, it talks about the public policy in Fiji. So the court cannot consider whether it's contrary to public policy in Thailand or not. The court which exercises the power to set aside has to look into its own law. If it is in Fiji against public policy only, the court can set aside. For the reason that is against public policy in Thailand, Fiji cannot set aside under their public policy. That is the answer for the first one. If you look at the second question, again, the same answer, the Fiji court cannot consider the public policy because in the second question, the tribunal has decided which law is applicable to the particular issue. So that goes to the merit of the matter, which the courts have no jurisdiction to set aside on that basis to question that procedure. Number 3 is again the question relating to the public policy and comes to the enforcement stage. The same consideration is applicable in number 3 too. So the public policy grounds in Fiji only to be considered, not in the other country. But sometimes if the public policy is like internationally accepted norms like corruptions and bribery, yes, the Fiji court has a jurisdiction to set aside on those grounds if that is satisfied on those grounds.
Thank you very much, Master Ajam. The observations are very good. Master Ajar drew a distinction between international public policy and domestic public policy, public policy of Fiji. And he drew attention to the fact that if this were a matter of real criminality, smuggling, bribery, corruption. Perhaps then, as a matter of public policy of Fiji, even though this would be wrong under Thai law, well, Fiji court cannot turn a blind eye to blatant corruption, blatant bribery, blatant smuggling, blatant criminality. And therefore, that may be contrary to the public policy of Fiji. But as a matter of setting aside, one looks at the public policy of Fiji. Now, this case actually came before me, situation came before me, and the argument was set up a little bit different. The argument was said to be Thailand is in a friendly relations with Singapore. It would be contrary to Singapore public policy to enforce or to recognize or to not to set aside an award that was contrary to the public order and good morals of Thailand. It would be wrong for the Singapore court, as a matter of Singapore public policy, to enforce, recognize, not to set aside an award that was contrary to the public order and good morals of a state with whom Singapore maintained friendly relations. So that was the way it was put before me. I found that a difficult proposition. I found this case very difficult, and I thought about it for quite a bit of time. Jonathan, would you have any insights, or would you like to add anything on this question before you leave us?
Am I audible now?
Yes, you are.
Okay. I was just saying Master Azhar captured our discussion quite well. I would just say that I think there's a question of I think we explored a separate question relating to interest, and maybe I'll just touch on that briefly. I think a question was raised in my session about what if no arguments were made of it on interest, and the judges then went on to, the arbitrators then went on to decide the question of interest. And I thought that was an interesting question, and we dealt with it in our group, and that's partly why Master Azhar referred to section 52, subsection 2A3, where we discussed how that might fall within that ground for setting aside, where an issue not raised by the party, let's say the claimant never claimed compound interest, but that was awarded by the tribunal, that would be a dispute not falling within the terms of the submission to arbitration. So I wanted to close that loop a bit. I think that was something our group discussed, and issues of interest sometimes raise these kinds of issues. On the point about public policy, I think it's right as a general rule that Fiji courts would look to Fiji public policy. I think our group discussed the qualifications to that general rule, which are where the breach of law in question rises to the level of a breach of international public policy, or where there are particular mandatory rules that may apply to the case, and where there's a breach of that mandatory rule. But those are limited qualifications, and in all other cases, I think it is still the public policy of Fiji that should be the focus of the inquiry. And even within those qualifications, the argument is that it is against Fijian public policy to enforce something that's contrary to international public policy, surely.
Thank you very much, Jonathan. And thank you very much for your assistance in today's colloquium. Could I just ask Daniel to say a few words about, we're often told that arbitrators can get the law wrong. Can you say something about what this actually means? And are there limits to this principle? Should the courts intervene when arbitrators get the law badly wrong? And which law?
That's an interesting question. The starting answer with that is, of course, the idea of international arbitration, the idea of the New York Convention, the idea of the UNCITRAL model law is that there is no review, there's no merits review of a legal error by a tribunal. That's the starting point. But having said that, and as Justice Reyes has indicated, there are ways in which parties seek to use elements such as lack of jurisdiction, elements such as lack of opportunity to hear, to weave into those arguments matters which may, in some senses, be merits-based. But at the end of the day, merits are not, getting the law wrong is not something which per se is available for review.
Thank you very much. Let's now go on to the last two questions. That is question 5.1 and 5.2. Is there anyone from group A or B who would like to speak to question 5.1? Anyone from group A or B? If there is someone, you can just unmute yourself and speak up. If there's no one, then let me do it. I'll do question 5.1, and then Daniel will do question 5.2. What procedures should be followed for enforcing the final award in Fiji, resisting enforcement of the final award in Fiji, setting aside the final award, if possible, in Fiji? Well, the question 5.1c, that seems to be a red herring, because the finding is that the seat of the arbitration was Hong Kong. So that's the arbitral tribunal's decision. If the seat of the arbitration is Hong Kong, then it would seem that you apply to set aside the award in Hong Kong. So it may not be possible. It may not be possible to set aside the award in Fiji. You can only resist recognition and enforcement of the award. What is the procedure? I believe the procedure is set out in Order 74 of the Rules of the High Court, and that is similar to the procedure in Hong Kong. The party in whose favor the arbitration award is made and who wishes to enforce it in Fiji takes out an ex parte application, that is, without necessarily informing the other side, and applies to have the award turned into an order of the court. The court then, if it's anything like the Hong Kong procedure, deals with the matter on paper and makes what is called an order nisi, a provisional order, turning the arbitral award into an order of the court. However, it's only a provisional order. The order specifies that the other side will have 28 days, or whatever is the appropriate time, to apply to set aside the order. And if the other side applies within the time limited to apply to set aside the order nisi, that is to applies for refusal of recognition and enforcement, then the order nisi will be suspended, its effect will be suspended, until such time as the other side's application for refusal of recognition and enforcement will be dealt with. Now, I rather liked this procedure because it's efficient. When I was in charge of the arbitration list, I would deal with applications to enforce arbitral awards on the same day that they came into court. I would make the order nisi, as long as all the documents were there and as long as I didn't see any glaring problem, and then leave it to the respondent typically to apply to set aside the order nisi, to set aside the provisional order within usually 28 days. If an application is made, then the order nisi is suspended until such time as the application to refuse recognition and enforcement is fully dealt with, even if necessary, fully dealt with on appeal. And this is an efficient procedure, since it means that the ball is in the respondent's court to apply to set aside the order nisi to apply for non-recognition, non-enforcement of the award. If it fails to do so, then the order nisi becomes effective. And now that's what I would answer to question 5.1. Daniel, would you like to deal with question 5.2?
Yes. Question 5.2 is whether there are different considerations to be taken into account when deciding whether to set aside an award or whether to refuse recognition and enforcement of an award. And if so, what are the differences? Well, the short answer is no. There aren't differences, but there are a few matters that are worth noting. I think the most important matter to note is when there are recognition or enforcement proceedings, there is often an application for the award debtor to provide appropriate security into the court pending determination of the proceedings. That's a fairly common application that you would face, and it gives obviously the parties comfort of knowing that there are monies essentially in court that you don't need to worry about dissipation of assets during those particular proceedings, provided there is appropriate proceedings. So the other point to be made there is that if a I'll just back up there. If a court is asked to set aside an award, it can, under section 52.4 of the Act, essentially, if requested by a party, suspend the setting aside proceedings for a period of time determined by it in order to give the arbitral tribunal an opportunity to resume the arbitral proceedings or take such other action as is in the tribunal's opinion, which would eliminate the grounds for setting aside. Now, that particular provision isn't available for proceedings resisting recognition and enforcement of the award.
Thank you very much. We still have a few minutes, and what I propose to do is I'm going to ask Daniel in a moment a hard question that I can't resist asking him, and let's see what he says on it. And then I will say a few closing words. And that question for Daniel is this. We've been talking in these proceedings about applications against tribunal findings that the tribunal has jurisdiction. So let us say that I complain to the tribunal that it has no jurisdiction. The tribunal finds against me and holds that I have jurisdiction, that it has jurisdiction. I don't bother to apply within 30 days to appeal against the tribunal's finding that it has jurisdiction. The award is made. Can I, one, apply to the court of the seat of the arbitration to set aside the arbitral award on the ground of a lack of jurisdiction on the part of the arbitrators? Two, can I apply in an enforcing state to refuse recognition and enforcement of an award on account of lack of jurisdiction of the arbitrators? Or am I stopped? Am I stopped because I didn't apply within the 30 days? This is a difficult question. It's one that has come before the Singapore court. I'm not sure we've heard the last word on this. Daniel.
My feeling is no to both, because two issues are at play here. The first is that you have a 30-day period to appeal. You have raised, presumably, the ground. It's been determined one way or another. I must say, more than often, tribunals tend to find their own jurisdiction, and you've then failed to appeal that in the time frame that you could. In one sense, what you would be doing by failing to do that is to reopen proceedings that you couldn't otherwise reopen, and I think in one sense that applies to A and B, because you're essentially seeking to raise the question of jurisdiction where you would otherwise be stopped, unless perhaps you could say that there is such new material that would effectively materially change the arbitrators, or would have changed the arbitrator's decision in scenario B, but you didn't have an opportunity to put it to them. So say, for example, there were subsequent allegations which sometimes occur of corruption, which would render, which would impact on the jurisdiction of the tribunal. Could you subsequently raise those allegations which had not previously been put before the tribunal on enforcement proceedings? And there are some mixed cases on that as well, whether you could reopen a case on that. But some judges have said, yes, you can, if there is fresh and new information that had come to light that the tribunal hadn't seen. But my reaction to A and B is no. But I'm assuming, Justice Reyes, you have a less simple answer.
I have no answer. That's why I was interested in your answer for my future reference. We've now got a few minutes left before we conclude at 4:30 Fiji time. We will conclude exactly on time. I just want to say a few closing words, and I limit myself to 3 observations. 1, we've covered a range of situations, a wide range of situations in this colloquium. There are no easy answers. There are no simple answers. There is no one answer. But hopefully what this colloquium has done is expose all of you, all attending, to the possible answers or the possible ways of thinking about the questions that you are likely to encounter in the future in relation to international commercial arbitration. So this has simply been a dialogue which has put out the options available, and then you'll have to decide the options when these actual cases come to you. We've been very comprehensive in the situations that arise, and I think that you'll find that the situations that come before you in the future will fall under one or other of the rubrics that we have discussed. The second, what COVID-19 has perhaps taught us is that we are not subject necessarily to the tyranny of distance. Yes, there are travel restrictions. Yes, there are quarantine restrictions. But with remote technology, we can overcome these travel and quarantine restrictions. We can overcome restrictions of geography, distance. So what it means for Fiji, a jurisdiction like Fiji, is that Fiji has the potential, through developing its expertise in international commercial arbitration, to becoming an international dispute resolution center, the international dispute resolution hub. It can become, we heard from the General Counsel of ADB, how various countries in this region were acceding to the New York Convention, were looking into the UNCITRAL model law, so Fiji can lead the way towards becoming a regional or quasi-regional international dispute resolution center for the South Pacific and perhaps internationally. So it doesn't matter that Fiji might seem to be remote or distant from the rest of the world. We know is international commercial dispute resolution involves going to neutral forums with the competence, with the expertise to deal with the sorts of problems that arise. So Fiji, one day, developing along the lines that have been started today, started in other colloquiums put forward by ADB and others, can start developing on its way towards developing itself, positioning itself as a regional or international dispute resolution center. It need not worry about the tyranny of distance or about remoteness. And the third is addressed to you all personally as judges. What I found in my career as a judge, and what I found in my career as an arbitrator, is that often, surprisingly, there is a fear of deciding. There's a fear of judging. There's a fear of making a determination, because one might be wrong. But I hope that what today has brought, the possibility, the discussion, the dialogue, has given you confidence in making a decision. There is an awful responsibility when you decide things. And sometimes we as judges may find that responsibility, that burden, a heavy one. And so we delay, we postpone making decisions. But I hope this discussion today amongst us, trying to work out ways of perceiving or dealing with problems, has for all of us one message. That is, do not be afraid. Do not be afraid to decide. Other people, other judges in other jurisdictions face the same problems, face the same struggles, and come to some conclusions. And in that, you are not alone. There is solidarity, and you can count on that solidarity to support you in times when you have to make difficult decisions. Thank you very much. I think that leaves Daniel to conclude today's session.
Could I just make some concluding remarks? Just some concluding remarks from me to say, first of all, having studied this case study today, and before it was presented to you, the presenters, Brenda, Joe, Johnny, and myself had a look at this. It was almost entirely prepared by Justice Reyes, I have to say, and the four of us essentially winced at the difficulty of the issues that were raised in this. We calculated we had about 70 years collective of international arbitration experience between us, and we found the issues raised very difficult in this problem. And I have confidence to say that after you've dealt with what was raised today, nothing will trouble you too much on the bench after this, I would have thought. The second thing I want to say is that you, of course, have the comfort of this being a model law. And what today has shown, and the cases that we've been able to look at today has shown, is that it's likely that in relation to each of the provisions in your Act, there already is some jurisprudence in there for you to have some regard to, and particularly the jurisdictions which are developed, such as Singapore, Hong Kong, Australia and New Zealand. There are some excellent decisions on most provisions that you will be dealing with. And the final thing I want to say is a thank you to all the presenters who are not on the line now, and thank you to you, honourable judges, for participating in this, for obviously reading up on the case study before you came and being able to meet the challenges that were presented, not only in the problem but technologically as well. And I thank the technical staff for their assistance today. I wish we could all applaud together, but the format of Zoom won't allow us to do that. But thank you very much, and look forward to future judicial colloquia with you. And thank you again.
Thank you. Thank you, Daniel. If I just may take just two minutes of everyone's time. Again, it's been a great opportunity for ADB to host a partner with the Supreme Court for the second judicial colloquium. As Justice Reyes said, you're not alone. As our general counsel announced, that ADB is here with further technical assistance to provide you with the resources. So we sincerely hope for a third judicial colloquium when the time suits. So again, we are just grateful for all the hard work you do. We understand the challenges, and I've heard some of the difficulties in adjudicating, just generally, just how tough your jobs are. So ADB is here with additional resources, additional technical assistance to help you in a variety of cases, including international arbitration and other commercial matters, as well as environment and climate change issues, and as well as gender. So again, thank you so much for your valuable time, and thanks to the presenters and of course our technical staff, which I will thank separately. They've been up since 2 a.m. this morning to make sure that everything runs smoothly. So really appreciate your time, and I really look forward to coming back to Fiji. As everyone knows, it's one of my favorite places. So thank you, and have a wonderful weekend.